Welcome to this special crossover edition of the Consumer Finance Podcast and the Payments Pros Podcast. I'm Chris Willis, the co-leader of Troutman Pepper's Consumer Financial Services regulatory practice. And today you're going to hear my colleague, Carlin McCrory, talking with several of our partners about the recent guidance from the CFPB about earned wage access products. But before we get into that discussion, let me remind you to visit and subscribe to our blogs, TroutmanPepperFinancialServices.com and ConsumerFinancialServicesLawMonitor.com. And don't forget about our other great podcasts, the FCRA Focus, all about credit reporting, the Crypto Exchange, about everything crypto, our privacy and data security podcast called Unauthorized Access, and our newest podcast all about the auto finance industry called Moving Metal. All of those are available on all popular podcast platforms. And speaking of those platforms, if you like this podcast, let us know. Leave us a review on your podcast platform of choice and let us know how we're doing. And if you enjoy reading our blogs and listening to our podcasts, our handy mobile app is a great way to do it. It's available for both iOS and Android. Just search for Troutman Pepper in your app store, download it, and give it a try. Not only does it have access to all of our blogs and podcasts, but it also has a handy directory of all of our financial services lawyers, and you can email and call us from right there in the app. So give it a try. Now, as I said, today we're going to be talking about the CFPB's recent guidance on earned wage access products. And you're going to be hearing a conversation led by Carlin McCrory, who's one of the hosts of the Payments Pros podcast. And she's going to be talking to our colleagues, Keith Barnett, Mark Furletti, and Jason Cover about this very interesting topic. So Carlin, let me just turn the floor over to you.
Well, thanks so much, Chris, for that introduction. And Keith, Mark, Jason, very much looking forward to our conversation today.
Thanks, Carlin.
Jason, as a preliminary matter, can you just describe what is EWA?
Yeah, I think EWA stands for Earned Wage Access, and that's kind of been convoluted a bit, and there's a variety of different paths that takes in the modern world. But at its core, it's basically a cash advance of some sort that's generally associated in some way or another with wages that are being earned simultaneously.
And then common parlance in the industry is to separate EWA between employer-partnered EWA and direct-to-consumer EWA. Can you describe the differences with those models?
Sure. I think employer-partnered is sort of the more traditional approach. And this is literally where most people get paid weekly or biweekly or monthly, and you're accruing earned wages on a daily basis every day you work, right? So in the traditional sense, the employer would literally provide the earned wages in advance of the payroll check and then deduct them from them. There's sort of hybrids of that where fintechs partner with various employers to help facilitate that process. But the idea here essentially is that this isn't really a loan. You're merely getting things that you've already earned in advance. There's no deferment of credit, as under most state or federal laws, that would kind of be the traditional definition of credit, right? In the direct consumer EWA, this is usually a fintech or a lender of some sort standing alone that provides a cash advance. Sometimes it is linked to, they may reference how much you receive over the pay period, or maybe have some tie to the employment or the earned wage. But essentially you're getting a cash advance. And the hook here is usually that there's no obligation or no recourse as to that advance. So again, it gets you out of most state and federal definitions of credit, because I get this advance, and if I don't want to pay it, I ultimately don't have to. Therefore, there's no deferment of a solid obligation.
And then can you also explain how would a provider make money off of an EWA product?
Sure, Carlin. I guess one of the other additional hooks that I didn't mention in describing EWA product is there's generally no finance charge associated with it. So you're not saying, look, you must give me $10 to get access to this type of credit, or not credit, as we'd argue. Instead, there's usually different types of fees or models. So one model would be to use expedited funding fees that are mentioned in the Bureau's bulletin. So that would be for same day transfers, it's $2.99 or something like that. Another model is the tips model, which has sort of been in the news over the last couple of years. And there might be like a wheel, and you can adjust it to give a tip, but it's not mandatory, right? You can literally get the same advance for $0 if you want. If you feel like the service was valuable to you, you can give the company a little bit of money. And then another model we see sometimes, but not as often in this type of product, is a subscription model where there's maybe someone pays $50 a month for a variety of products of services, and EWA cash advances is one of them.
Thanks for that. And then can you also explain a little bit, Jason, the differences between earned wage access and payday lending?
Sure. I guess in some ways they look very similar, right? It's usually something tied to your pay date. There's a cash advance. There's usually a payment authorization for the amount of that advance. I think critically, there's no fee. So the vast majority of payday statutes and almost all payday transactions are basically going to be a cash advance in exchange for a fee and the payment authorization in the amount of the advance and the fee. That's you could cover probably 75% of the statutory definition of payday loans at a state by state basis with that. And that would describe almost all payday loan transactions as well. Whereas here we've got a cash advance, but no, we may have a payment authorization, but there is no fee imposed. And then critically again, right, the payday loan is an obligation. I mean, there is no excuse for not paying. It is a true obligation and the creditor has complete recourse. So those are sort of the critical differences in my view.
Mark, didn't we already have guidance from the CFPB on EWA? Can you tell our audience a little bit about what happened to that guidance?
Sure. In November of 2020, under Director Kreninger, the CFPB put out an advisory opinion that related to a particular type of EWA program. And that particular type of program involved an integration between the provider, the EWA provider, and employer. And that advisory opinion said that when you have this integration that enables the provider to see how much in wages the consumer has earned, that under certain circumstances, and there were multiple factors, but if you met these various factors, then it was not that product was not subject to the Truth in Lending Act. And it didn't primarily because it didn't meet the definition of credit, because the consumer in that case was just obtaining access to wages that they had already earned. So there wasn't an extension of credit there. And so that guidance had been in place since November 2020. And then in connection with this proposed interpretive rule that the CFPB just published, they are going to proposing to rescind or replace that prior guidance, the 2020 guidance, with this new guidance. They basically are saying that guidance related to a product that is no longer prevalent in the marketplace. And they also thought that prior guidance created uncertainty and confusion. And of course, that guidance was kind of, I would say, more favorable to the industry. And now they're replacing it with guidance that seems much less favorable, just more evidence of this kind of like ping pong approach that depending on who is kind of administering the agency, you can get somewhat conflicting views on similar questions, which is obviously not good for regulatory certainty.
And following up on that, Mark, what EWA products does the proposed interpretive rule apply to?
Yeah, so the proposed rule, the CFPB, it says that it applies to products that have two characteristics. One, the provisions of funds to consumers in an amount that's based on the wages that they have accrued during a given pay cycle. So some tie into how much a consumer might have earned up to that point, kind of maybe, let's say, mid-pay cycle. The CFPB notes that a number of consumers have relatively long pay cycles where historically maybe more employees had weekly pay cycles. Now a number of them have biweekly or monthly. So there can be a long delay between when an employee actually earns wages and then those wages are paid to the employee. So first, it's kind of like the product would involve looking to setting the amount of the earned wage access to the amount of wages that have been earned by the employee. And then second, repayment to a third-party provider. So I think by third party, they mean some provider other than the employee via an automated means. So for example, an ACH or a debit card debit. So it's a pretty broad definition. And I think I would criticize it because it doesn't actually include some of the definitions of any of the elements or prongs of the definition of credit under Reg Z. So it's just kind of like you provide funds and you repay it. And of course, they're going to say that this is subject to the Reg Z Truth in Lending Act, but yet they don't define it in a way that, kind of on its own, standing alone, meets the characteristics of credit under Reg Z.
And moreover, to that point, what requirements would apply to these products that the Bureau is proposing under the interpretive rule?
Yeah, so the key point of the proposed interpretive rule, and as an aside, right, this is a proposal. It's interesting because the CFPB seems to be taking a different approach here than they took on the buy now, pay later rule, which was to just or interpretive rule, which was in effect making new law out of whole cloth and then just jamming it down on everyone with almost no notice period. Here we have them doing something that's similar, but saying there's a proposal, taking comments, and then I expect, though, that they'll probably push this down on folks with almost very little time to prepare, similar, in a similar way. In any event, the point of the interpretive rule is it says that the Truth in Lending Act, namely Regulation Z, covers these products, importantly, when there is an obligation to repay debt. And so to the extent that the law was not clear about that previously, they are seeking to clarify that. And basically, as folks may know, Truth in Lending Act is largely a disclosure statute requiring, particularly for closed-end credit, the disclosures that must be provided in connection with the origination of a loan obligation.
Mark, I'm curious if you agree. My read was that regardless of whether there's a legal obligation to repay, the CFPB seemed to take the position that requiring a payment authorization, even if one could terminate it after the fact, creates a obligation and thus credit.
Yeah, I mean, I think, the agency is constrained because they are only able to regulate credit as defined by the Truth in Lending Act. And so they're trying to shoehorn a bunch of products, some of which may meet the definition, some of which may not, into that definition. And so, yeah, I think they're making that argument. Now, whether that's valid, I think, is another point. But yeah, I would agree with you that they're arguing that somehow even if there is no obligation to repay, that if there's just merely a payment authorization, that constitutes an obligation to repay, despite the fact that could be possibly canceled at any time without consequence.
And actually, Mark, to that point, you guys bring up an excellent point, because that is the concern that I have for the fintechs that are out there that are just providing the technology without providing the funds, right? And there are fintechs out there who provide the tech for the employers, and the employers are the ones that provide the funds. But the interpretive rule says that in an earned wage transaction, the consumer incurs an obligation to pay money at a future date. They just make a blanket statement like that's the definition of an earned wage transaction, when we know that's not necessarily the case in all instances, especially when you have the example that I've just given with a fintech. So that blanket statement is not necessarily true, and it could be considered to be misleading. And I guess it was done in order to allow for a TILA or Reg Z hook. And I say that because in an regular or in an other EWA transaction, the consumer does not incur an obligation to pay money at a future date. Instead, the consumer is obtaining money that it had earned at an earlier date. And consumers are not paying money or an obligation to pay. And so, but then they go out and say that TILA/Reg Z does not apply to regular payroll transactions, because when an employer pays wages, there's no later act of payment, repayment required, deduction, or otherwise. So they're saying two things all at once, because the case with EWA, when a fintech is providing it, is that the fintech is providing the technology and the employer is still paying the wages. So it just doesn't, the rationale here just does not make sense.
Keith, I'd add to that too, they don't identify a consumer harm why there needs to be this distinguishment between the two, right? I mean, I think this is, on the whole, can be a very, very good and helpful product to a lot of people, particularly who need funds in advance. It kind of belies the question of, well, why is this needed in any event?
No, that's absolutely right. Because if you think about it, the CFPB has been on a mission to have some sort of regulatory scheme against payday lending. Let's just be honest here. And so you have something that is not payday lending, right? People only have access to their earned wages. And in many instances, only a certain percentage of their earned wages. So they're not going above and beyond anything that they've already earned. But the CFPB is trying to regulate this by shoehorning TILA and Reg Z into this when that really does not apply in most instances. I agree with you.
And it does seem everyone forgets that, at least one of the CFPB's reported goals is to expand access to credit, right? And I think this has the opposite effect at the end of the day.
And Mark and Jason, I'd love to get your thoughts on two focal points of the guidance are expedited funding fees and tips. Can you all discuss what the guidance says about these?
Carlin, for both instances, the CFPB wants to take the stance that these are finance charges, which, to Keith's point, then gets you the hook to require TILA disclosures. I think it's pretty interesting to take a look at that definition. If you look at Reg Z, it says a finance charge includes any charge payable directly or indirectly by the consumer and imposed directly or indirectly by the creditor as an incident to or a condition of the extension of credit. So the CFPB really honed into incident to an extension of credit. And they sort of admit that, this isn't explained anywhere. They're going to like Black's Law Dictionary and things of that nature to try to pin something like a optional tip as something that is incident to an extension of credit. But at the same time, they completely miss the word several words before that has to be imposed by the creditor. So it's really hard to understand how something that is completely optional and at the choice of the consumer is something that's imposed by the creditor, even if it is somehow incident to the extension of credit. It seems to me to be a very, very weak rationale and argument and something that's ripe for challenge.
I guess just on the expedited funding fee, the CFPB makes mention of a case, but that a 1996 11th Circuit decision, Veal, V-E-A-L-E, v. Citibank, that involved basically an expedited funding fee. It was a Federal Express charge for Federal expressing a check with the proceeds of a loan, and the fee was $21. And the question before the court was whether or not that $21 Federal Express charge was a finance charge. And the court held that it was not. They said since the Veals could have chosen not to pay the Federal Express fee and the bank did not require it, then the fee was not imposed as an incident to the extension of credit and need not be included in the finance charge. So the CFPB argues that that was wrongly decided to some extent in a footnote in the proposed interpretive rule. But I think it sets up, we now know in the wake of Loper Bright that the CFPB's interpretation is not entitled to some extra weight above and beyond, for example, the 11th Circuit or any circuit court. And so I think it sets up, at least there's probably multiple areas for challenging this proposed rule, assuming it gets adopted, or in the event someone wants to challenge it beforehand. But that certainly has, I think, pretty strong grounds for challenging it.
Mark, do you have any parting thoughts on the proposed interpretive rule?
Yeah, obviously, I've been pretty critical of it. And so I think there's an opportunity for market participants, particularly those who are going to be impacted by it, to submit comments to the CFPB. Comments, I believe, are due by August 30th. So not that far off from the day we're recording today on August 6th. And so I'd say submit comments and pointing out the kind of flaws in the CFPB's analysis, that would probably be a good idea.
Well, Keith, Mark, Jason, thank you so much for your time today.
Thanks, Carlin.
Thank you, Carlin.
Thanks, Carlin.
And Carlin, you did an awesome job of leading today's episode. So I'll just close things out quickly. Let me thank you and our guests for being on today. And of course, thank our audience for listening. Don't forget to visit and subscribe to our blogs, TroutmanPepperFinancialServices.com and ConsumerFinancialServicesLawMonitor.com. And while you're at it, why not head over to Troutman.com and add yourself to our Consumer Financial Services email list. That way we can send you copies of the alerts and advisories that we send out from time to time, as well as invitations to our industry-only webinars. And as I mentioned at the beginning of the show, don't forget to check out our handy mobile app. Just search for Troutman Pepper in your app store and check it out. And of course, stay tuned for a great new episode of these podcasts, the Consumer Finance Podcast and Payments Pros, right on your podcast feed. Thank you all for listening.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.